welcome to a lecture on John Marshall, the last of the Federalists and the last of the Federalists to be able to put his mark on the nation. John Marshall was Chief Justice of the Supreme Court, and the courts are often named after them, like the period. So this is the Marshall Court, and then there are other later courts. Today we're in the era of the Roberts Court here in 2015, Chief Justice John Roberts. And the Chief Justice, he's not the only justice, he's not the only opinion on the court, but he certainly has a lot of influence, in deciding what cases are going to be heard. So he had, as one of the first Chief Justices, he got to make a lot of important precedent decisions. And he was definitely a loose interpreter of the Constitution, and he definitely sort of favored the ideas of Hamilton and Washington, these Federalist ideas. And he's going to stay on the court all the way through this Jefferson and Madison and Monroe time, right up into the 20s and even the early 30s. Chief Justices, they stay in for life or until they choose to retire. So his decisions at the court cases, the one I'm going to look at the most is McCulloch versus Maryland. And this is about the National Bank, and it's the decision on whether or not we can have a bank. And we've got the two arguments, and we'll look at these in more detail in class. Maryland had a state bank. McCulloch worked for the National Bank, and he was found guilty of Maryland state laws, and by running the bank. And it came up to the Supreme Court to make a decision on it. And when we say McCulloch versus Maryland, really what we mean here is the national government versus the state government is this court case. And John Marshall is going to agree with the national government, and the last part here is saying the Constitution is the supreme law of the land, and Congress has the power to do what is necessary for running the country, therefore they can have their bank. And he blows away Maryland's defense of it, or the state's argument against a national bank. So loose interpretation, and national government is supreme, so quite important for that. And now it really opens up, the national government to using its implied powers, which is the elastic clause. That powers they might not be specifically mentioned, but it's implied within the necessary and proper clause that they can do it. And he rules that Maryland's actions trying to destroy the national bank is an affront to the sovereignty of the nation, and that the federal government is supreme, it is primary over state governments. Now, other key Marshall decisions, Cohens versus Virginia, Gibbons versus Ogden, Fletcher and Peck and Dartmouth College, we see a commonality with them. They're asserting the power of the national government, creating a stable business environment, and that the Supreme Court is the final arbiter, the final decision maker. So that's what Cohens in Virginia is, asserting the authority of the national Supreme Court to review an individual state case. So this was a case that was within Virginia itself, and Virginia won, and the Cohens decided, well, let's appeal our case, the state court decision case, to the national government. And the national government, John Marshall, they said Virginia's correct. They still win, and Virginia says, good, yay, we win. And then all the states said, wait, maybe we all kind of lose, because the national Supreme Court has just sort of set the precedent, the idea that they can rule over decisions made at the state level. Gibbons versus Ogden, these are, think of it like Uber and taxis today. It's sort of a fight over the right to operate a ferry between New Jersey and New York. They're separated only by the Hudson River. And New York had sort of established laws that favored, one guy over the other. And these two sued each other, and it came up to the national government, where the court said, New York, you can't have a law regulating ferry service between one state and another. That's the national government. They regulate interstate commerce, which is any kind of commerce business being done over more than one state. So something like, ferry service between two states, those two states cannot make any laws. It has to be the national government. So asserting the power of the federal government there. And these last two, Fletcher Peck, Dartmouth College, Woodward, John Marshall and the Supreme Court establishes the idea that contracts cannot be invalidated. So, for example, the college one, Dartmouth College had received its original charter to operate from the King of England, way back in the colonial times, and I believe it was New Hampshire. They sort of tore that up and created a new charter, and the Marshall Court said, whoa, that was a contract, and you can't just tear it up like that. Contracts are have to be sacred. They cannot be so easily just tossed out, even by a government, and they're binding. And so this is really helping to establish in the United States the notion of a contract is binding. So, for example, if I hire somebody to fix something in my house, maybe put up a new roof, we're going to hammer out a contract. I can't break that just on a whim. Neither can the guy I've hired. That once we've signed it, it's a deal, and if you're unhappy with the terms, well, sorry, but you're going to have to renegotiate a new one. You can't just walk out on it. And this is going to very much help the business community. So in all of the cases, we're seeing laying down a foundation for commerce and business, and that the national government is supreme. It's really going to leave his mark, John Marshall and the Marshall Court. All right, thank you very much.